My name is Ansie Ramalho. I'm the chair of the King Committee on Corporate Governance for South Africa. And I'm joined here this morning by my colleague, the Deputy Chair, Mr. Mohamed Adam. Just by means of context, I will give a short introduction to the King Committee and its work. The King Committee is run under the auspices of the IODSA, but we have autonomy and independence when it comes to the development of the content of the King Codes. The institutions represented on the King Committee include the Auditor General, SIPC, the Financial Sector Conduct Authority, IRBA, the JSE, National Treasury, SAICA, and others. Of course, our presentation today is the view of the King Committee collectively and not of any one of these institutions. Our task as the King Committee is the issuing of guiding practices for corporate governance. Now, these guiding practices give effect to the legal duties as per the Companies Act and are therefore rather important. For the most part, these guiding practices are voluntary, with the caveat that it's, as Mr. Visser has already explained, that the King 4 recommendations are incorporated in the JSE listings rules, and also our courts use King 4 as a reference point when determining whether directors acted in accordance with the standards of conduct as set out in the Companies Act. Before I get to our specific comments, I think it's important that I state as the King Committee that we are absolutely in favor of the reform efforts of the bill. We agree that measures that will enhance accountability and that will address inequality are necessary. I think where we have comments, it is rather about the way exactly in which it is proposed to be done. So the two aspects that we will focus on in our presentation will be the access to company records as per Section 26, and then the other issue, that of the vote on remuneration and the disclosure of the wage gap. Before I get to our specific comments, we do agree with the tabling of the remuneration policy for a shareholders' approval. We believe that it is constructive and in line with international leading practice. That's as far as the policy is concerned. I will deal with the implementation report in a minute. As to the disclosure of the wage gap, again, we agree that such disclosure is in the interest of enhancing accountability and in the interest of actions that could potentially perform to address inequality. Which brings me then to our specific recommendations and the comments that we want to raise on three issues. The first being the Section 26, which provides for access to company records. Our concern as far as this is concerned is that with the proposed amendments, our reading and interpretation of the amendment is that it will mean that any person, regardless of whether that person holds a beneficial interest or not, can access company records as stated, including the annual financial statements of a private company, a non-profit company, or a personal liability company that has above a particular PI score as outlined in the bill. We're not sure what the rationale of this proposal is and what its intended benefits may be. But it's a huge departure from the current position where private companies are by nature, some of the information is treated as being private. We think that this proposed amendment goes against the character of a private company and the purposes for which it is incorporated in this form. We also think that it may very well be inconsistent with privacy legislation. So our recommendation then is that access to company records in terms of Section 26 be limited to beneficial interest holders, and that it's made subject to the promotion of access to information and other privacy legislation. That's as far as our first comment is concerned. Our next comment is on the pay gap disclosure. As I've already stated, we would welcome such disclosure in the interest of accountability, in the interest of addressing inequality. Our recommendation just is with regards to the methodology for disclosure. We recommend that the disclosure should be required to align with the requirements of the Department of Employment and Labour by using the form EEA4. This form covers the disclosure of pay gaps for specific groups and level of employees, the specific groups that it addresses in addition to what is required in the proposed subsection is that of marginalized or previously disadvantaged employees in accordance with race, gender, and disability categories. We believe that using the form EEA4 has several benefits. The information is it's a more pragmatic approach in that it aligns existing legislative requirements, and also we believe that the format as per form EEA4 is more informative than the disclosure as proposed in the bill. Our comments really are, like the JSE's, focused on the voting on the remuneration implementation report. And here I will probably repeat much of what the JSE has said, but I will try and supplement it by giving a supplementary perspective. So we've already stated that we support the proposed vote on the remuneration policy, but not on the remuneration implementation report. The policy, of course, is the forward-looking document that stipulates the approach to be taken to remuneration and the principles that will be followed in the design and the setting of remuneration. The implementation report, in contrast, is where the company accounts for the outcomes of the implementation of the policy. In other words, how the policy translated in actual amounts being paid to the executive. It's an account of events that had already taken place. In this way, it's similar to the annual financial statements, and it's because the annual financial statements provide retrospective information that it's not subjected to a shareholder's vote, but simply presented at the AGM of a company in terms of the Companies Act. A binding vote on the remuneration report with the adverse consequences as provided for in the bill is not practiced in any other jurisdiction internationally, simply because it's ineffective to try and unscramble the remuneration egg. It's a fait accompli by the time that it gets to voting. The implementation report, in our view, should be presented at the AGM in the same way as the annual financial statements are presented, and in the same way as it's now proposed in the bill that the Social and Ethics Committee report be presented. If this course of action is followed, it doesn't mean that shareholders do not have recourse. Where shareholders are dissatisfied with the outcomes of the policy and or the discretionary actions taken by the board with regards to executive remuneration, they should ensure that the policy is amended to address concerns and to clarify the extent to which the board has a discretion in terms of the policy. So that is far as our comments are concerned on the actual voting of voting on the implementation report, and I've motivated now why we believe that the remuneration implementation report should not be subjected to a vote. In the next section, I will then deal, or in my next slides, I will deal with the consequences of the vote failing as a separate issue. When the vote fails, as we've heard this morning, it means that remuneration committee members must step down as committee members for a three-year period. They don't step down as board members, only as committee members, but as the JSE has explained, also we believe that it's still very disruptive. I can also just point out that the remuneration policy is tabled for approval every 3 years, or when significant amendments to it is made. By its nature, the remuneration implementation report will have to be voted on every single year. This means that a remuneration committee member who has not even been a member for a year on that committee could be compelled to step down if the voting on the implementation report does not pass. And that's just an example of one of the consequences. We believe that the stepping down consequence may prove detrimental to what the envisaged outcome of this amendment is. We understand the amendment to address accountability and oversight on executive remuneration. But we don't believe that this will be the case with this consequence of stepping down. Firstly, in instances where the remuneration committees need to step down after a failed vote, the directors with the best qualifications and experience for the job will no longer be eligible to serve on the remuneration committee. This means that the consequence in this situation is that a company will have its B team serving on the remuneration committee. It needs to be pointed out, as was done by the JSE, that executive remuneration is a specialist area and discipline. It's a scarce skill. The boards of bigger companies, where executive remuneration is actually the issue, profile and seek directors specifically to serve on the remuneration committee. That's why they invited to join the board. I mean, one of the concerns that are raised in relation to executive remuneration very often is the dependence on remuneration consultants. And the concern is that remuneration consultants may potentially be biased by the fact that their fees are paid by the very management on whose remuneration they are supposed to advise. And so independent remuneration committee members, the independent board members who serve on the remuneration committee, play a critical role in challenging the advice received from remuneration consultants. And we use this just as an example of the consequences that may follow from having the remuneration experts having to step down as a consequence of a failed vote. The second reason why we don't believe that these consequences will actually achieve the aim of the bill is because it will have a negative impact on the reputation of South Africa as an investor-friendly country. There was a question about it, has been explained by the JSE. Because of its disruptive consequences, it's also not in line with the policy imperative of the bill, namely ease of business. The third adverse consequence, we believe, is of having this vote with its consequences on the implementation report, is that it will potentially disturb the balance of power between the board and shareholders. Shareholders could potentially hold the board hostage through a threat to vote down the implementation report if their various demands are not met. So, in conclusion, none of these potential consequences will not achieve the envisaged aim, in our view, of better oversight and accountability of executive remuneration, as the scarce expertise that can facilitate this, in other words, that can facilitate accountability and oversight, will be eroded. So our recommendations then is that ideally our preferred option is that the remuneration implementation report be presented at the AGM in the same way as the annual financial statements are presented, and in the same way as it's proposed the Social and Ethics Committee presents its report to the company at the AGM. We do, however, we do think that the current dispensation, as provided for in the JSE listings rules and as provided for in King 4, namely that there's a non-binding vote, and that if the non-binding vote fails, that engagement is triggered, we believe that that is sufficient. We do, however, acknowledge that this engagement fails in some instances in the current dispensation because of sometimes apathy on the side of companies to reach out to shareholders who voted against the implementation report, and sometimes, on the other hand, because of shareholders not being forthcoming on the rationale for their decision to vote against the implementation report. So if it is then considered necessary to strengthen the current arrangement, we believe that it could be strengthened not by requiring the remuneration committee members to step down, but rather to enhance the quality of engagement between the company and shareholders. And that can be done, we believe, by compelling engagement by the company in the instances where the vote on the implementation report failed, if the legislator then decides to implement the vote, and further than compelling the company to engage, also then to compel shareholders who hold above, let's say, 3% of the shareholding to disclose the rationale for their voting against the implementation report. By including engagement as a mandatory legislative requirement, and also the process along which it will happen, and addressing the responsibilities of both parties to the engagement, there may potentially be a role for the legislator to step in. So, Madam Chair, thank you very much. That's in short the comments by the King Committee.
Thank you very much, Mr. Ramalho. Members, I'll take hands for interaction with this presentation. Honorable Thring. Honorable Thring.
Thank you, Chair. Chair, South Africa, just one question, maybe two. South Africa currently has the largest stock exchange in Africa, and it is said about the 20th largest in the world. So the first question is, what is the comparative earning to Mrs. Ramalho? What is the comparative earnings of South African directors versus directors in other similar companies on other stock exchanges? Do we know whether our directors are overpaid, underpaid? Are we on par? So what are the statistics on that? And the second question is, how do we compare in terms of the discrepancy between the top 10% and the bottom 40%? Thank you, Chair.
It seems like there's no other questions to you. Oh, I see Honorable McPherson.
McPherson. Thanks so much. I find it fascinating that the chair of the committee for the King Code effectively is rebuffing what the department said to us, that this is in line and to bring the bill within line within the King Code. Sorry, I shouldn't say the chair of the King Committee, the chair of the board of directors, and it is exact opposite actually of what the committee, well, no, not the committee, the department has told this committee. And I would just like some comment then on maybe from the chairperson of the board of directors, actually in your sort of guess, how far removed this may be potentially from the King Code. Thanks so much.
Thank you very much, Honorable McPherson. Ms. Ramalho, over to you.
Madam Chair, thank you. Thank you for those questions. So I do believe that the earnings of our executive compared to that of the executive elsewhere, it's very difficult sometimes to make these comparisons because there's no direct comparison that can be made. It depends on buying capacity. Those things come into that comparison, and there may be some of my remuneration colleagues on the line, or even the deputy chair of the King Committee who can also comment on that. But in general, I think it is comparable. In fact, that is sometimes what is used as a justification for the level of executive remuneration in South Africa, is to say that our members of the executive, and specifically CEOs, are the pool is an international pool, and therefore as South Africans we need to offer salaries that are competitive, not only in South Africa but also internationally. Like I said, there may be somebody who could supplement this information on the call. As to the top 10% and the bottom 10%, I'm not aware of any statistics available, reliable statistics. the issue is that there is no disclosure on this at the moment, and therefore it is very difficult to compile these statistics. And so that is, of course, what the bill is attempting to address, and that is what we full-heartedly support. But as I explained in my presentation, we just think that there's a more meaningful way to do it, and a way that is more coherent with other pieces of legislation. So I just want to also then explain where, as the chair of the King Committee, when I say that some aspects of the bill are not aligned with international leading practice, I don't mean to say that none of it is. For example, the voting on the remuneration policy as opposed to the implementation report, that is very much in line with international requirements. In Australia, for example, there is the requirement for voting on remuneration outcomes, but in other words, similar to voting on the remuneration implementation report. But in that instance, as was also explained by the JSE, companies are allowed 2 strikes before the remuneration committee needs to step down. And that's a more reasonable approach because I mean, surely remuneration committee members, who some of whom may not have been on the committee for even 1 year, should be allowed an opportunity to engage with shareholders to understand where the pressure points are, where the objections are, where they are misaligned, so that they can rectify it before they are required to step down. So we're not saying the bill is completely misaligned, but we're saying that there are aspects where the bill is misaligned and that there are reasons for that misalignment. As I've explained in my presentation, there's a reason why retrospective information is normally not subjected to a vote. It's because the remuneration has happened, the egg has been scrambled, as I said. Thank you, Madam Chair.
Thank you very much. Can I check with the Deputy Chair, Mr. Adam, or any of the team, if they want to add to the responses?
Thank you, Chair. I hope you can hear me and see me properly. I've just had a problem with my connection.
Yes, I see your
so on the remuneration.
Can I ask you to switch off your video? We've seen your face so that your network is a bit better. Okay, you may proceed.
Thank you, Chair. So, compiled locally. Chair, the other comment I just wanted to make is if you look at one of the cornerstones of the King Committee, it's about ethical and effective leadership in the context of social, economic, and environmental performance. And that is the heart of the King Committee. And in the King 4 report, you'll also see that the King Committee has highlighted the importance of responsible and fair remuneration practices. So insofar as that is concerned, there is alignment in terms of the principles we're trying to achieve. I think the point that we're making, and a number of speakers this morning, and in particular the point that Ansie is making, is that if we look at mechanisms to achieve better governance in the country or in general, we need to look at an institutional framework that is able to balance regulatory mechanisms, legislative mechanisms, and then effective leadership, which is voluntary mechanisms. The directors of companies have particular duties to run the companies in the best interest of the companies, and that must be allowed. If that balance is not right, what happens, Chair, is you then have the result of over-regulation or not getting that balance is dysfunctional behavior, and secondly, and more importantly, unintended consequences. So you could disrupt governance by having consequences like the stepping down rule in an environment where you're trying to get good directors, where you're trying to address issues around diversity, and to add this additional hurdle might not be beneficial. And there is also no proof really that this is beneficial and will lead to better remuneration practices. I think Ansie has mentioned, if you look internationally, there is no example anywhere in the world where there is a step down or a binding vote required for an implementation report, or step down required in this regard. Thank you, Chair.
Thank you very much. Are there any, we have a bit of time, any concluding remarks, Ms. Ramalho?
No, thank you, Chair. I'll stand by what I've said.